Hello everyone, welcome to Lex News. So for today's session, we'll be discussing about defense of mistake. So my name is Ali Faiz and my partner is
Tan Wei Ling.
So Wei Ling, do you know what is defense of mistake?
Yes, the word mistake, it is not defined in the Malaysian Penal Code. However, in the Ratanla and the Ralaj Law of Crimes, a mistake of fact is actually occurred when someone had misunderstood, unaware or forgets an essential facts which related to a particular circumstances or transaction. It is a mistake when a person believing in something which actually is not in existence. There are two types of mistake, which are mistake of fact and mistake of law. Firstly, Section 79 and 76 of the Penal Code is pertaining to the defense for mistake of fact. Example for mistake of fact is that a police officer who arrests someone under the mistaken belief that the person has actually committed a criminal offense. The officer might invoke the defense under Section 76 if they believing the arrest was justifiable and they were acted under good faith, even though the facts are actually incorrect. On the other side, mistake of law happens when someone is actually unaware of the law itself or misunderstand the legal requirements to perform an action. For example, if someone failed to pay tax to government but later claims that they didn't know it was illegal, then obviously they are making a mistake of law. Malaysia adopted the principle of ignorance juris non excusa, which is that ignorance of law is no excuse, meaning that people are expected to know the law and not knowing it does not protect them from criminal liability. So to conclude, the main difference between both mistake of law and mistake of fact is that mistake of fact is a person's misunderstand or unaware of the fact of the situation, whereas mistake of law happens when a person is unaware or misunderstood for the law itself. Usually, mistake of law is not accepted as a valid excuse for breaking the law.
So in Malaysia, as we all know, these offences is governed under Penal Code Act 574. So this also can be seen in the Section 76 and 79, where Section 76 mention about it's protect individuals who believe that they are legally required to perform an act due to a duty or obligation, while Section 76 mentions that it applies when someone mistakenly believes that the actions are justified by law as long as the actions are not unlawful. So in this both section, it's mentioned that the accused must show that they had a bona fide belief, which is a good belief that they were either following law or justified by law. Okay everyone, we just received a new media coverage by our reporter regarding to this issue. Miss Alia, can you hear me?
Yes, I can hear you.
Hello, Alia. Could you tell us what had actually happened in the scene?
Yes, sure, Wei Ling. The case is still under investigation, and so I think it's better for us to focus on the importance and strength of the legal provisions, and so I will pass to Mr. Kalish.
Right, thank you, Ms. Alia. So basically, there are strengths for this defense of mistake in criminal liability, which is it protects individuals from any potential injustice and it ensures fairness. Section 76 and 79 of our Penal Code in Malaysia help in protecting any individual who believes that the act were bound by the law and justified by the law. A mistake of fact can only serve as a defense if it causes a person to be unaware that their actions are prohibited by the law. It is injustice to punish an individual who genuinely believes that he did not disobey any law. We can see this in the case of Chirani and State, a past case where a father killed his son because he thought he was a tiger that tried to attack him. So therefore, the court held that accused was not guilty since he was justified by the law to kill a dangerous animal. And it was specifically a mistake of fact that he genuinely thought his son was a dangerous animal. Obviously, these provisions also have its weaknesses, so I'll pass back to Ms. Alia to explain it further.
Thank you. For me, the weaknesses of the legal provisions in the defense of mistake specifically have its own weaknesses as follows. First, the mistake of law is generally not an excuse. Secondly, the mistake of fact actually have a limited applicability. And third is the subjective nature of the defense. And lastly is the lack of clear standards of what constitutes a mistake. The said weaknesses can be demonstrated by looking into the case of R against Tolson, where the Court of the Appeal held that Mrs. Tolson's belief, although mistaken, was reasonable given the circumstances. Her mistake of fact that her husband was dead was considered valid because it negated the mens rea intention to commit the offence of bigamy.
I think the media coverage is ready, so I will pass it to Mr. Ephraim. Hello, Mr. Ephraim.
Alright, okay. Basically, the case has already made its judgment. This case involves a police officer and the usage for the defense of mistake. The Crown Prosecution Services, or CPS, recently declined 2 press charges against Officer W80. The case dates back to 2015 when Officer W80, a specialist firearms officer, fatally shot Jermaine Baker during a high-stakes operation to prevent a prisoner escape. The officer claimed he acted out of an honest belief that Mr. Baker was reaching for a firearm, but it later emerged that Mr. Baker was indeed unarmed. Under criminal law, the defense of mistake allows an individual to justify their action if they genuinely believe the circumstances required them, even if that belief was mistaken or unreasonable. This principle, enshrined in the Criminal Justice and Immigration Act 2008 of the English law, became central to the case. After reviewing the evidence, the CPS concluded there wasn't sufficient proof to disprove Officer W80's claim of self-defense. In other words, they could not establish beyond a reasonable doubt that his actions were unlawful. While this decision does not officially endorse the defense, it highlights how the law prioritizes honest belief in assessing self-defense claim. This decision underscores the complexities of applying defenses of mistake in high-pressure situations, particularly of law enforcement officers. For now, CPS decision does not prosecute has added another layer to the ongoing discourse on the balance between public safety and accountability in the use of force. Back to you in the studio.
To summarize, defense of mistake is one of the defense applicable under Chapter 4 of the Penal Code. Basically, there are 2 forms of mistake considered in criminal law, which are mistake of fact and mistake of law. Mistake of fact negates the criminal intent, which is mens rea for a particular offence. This defense is governed by Section 76 and 79 of the Penal Code, while mistake of law can rarely be used as a defense as each individual is expected to have the knowledge regarding the law. There are several strengths and limitations when invoking the defense of mistake. Hence, it is necessary to differentiate explicitly the similarities and differences of both defenses, as it is pivotal for us to know that the wrong application of both defenses may lead to significant legal consequences. For example, frequent misapplication of these defenses will undermine the legitimate uses for this defense in future cases. More and more negative precedents will be established. This causes the future defendants may face a higher burden to prove the claim, even if they acted in a genuine and reasonable manner. Therefore, it is important for the defendant to invoke the appropriate defenses accurately to avoid a series of negative impacts. Lastly, why this defense is important? The existence of defense from mistake of law and fact is crucial as to uphold fairness and justice in criminal law. Malaysia's case had usually invoked the defense of mistake during the court proceeding. Hence, Malaysia had now in an endeavour of improving the legal framework and its implementation in regards to these defences, so that it can improve much better in the future, which lead to greater fairness and public confidence in the system of judiciary. Hence, defense of mistake is one of the crucial defenses in criminal law. That's all from our Lex News. Thank you.
Thank you.